See if my mic is on. Can you guys hear me? All right, that's better. I call this hearing to order, and for these hearings, we follow an agenda. The agenda's been posted publicly, but the first item, which won't surprise you, is the call to order. We just had that. The second item on the agenda is the pledge to the flag, so I'd like to ask you to join me as you are able. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Thank you. The next item on the agenda is dealing with the minutes from the Wednesday, April 15th hearing. I have reviewed the minutes. Are there any proposed changes, modifications, deletions, additions? I don't hear any, and I don't have any myself, so I'll go ahead and approve them.
Staff updates. We have 3 continued cases. Goulash, Schuler, and Myers.
Which ones?
Goulash.
Oh, Galusha? Okay.
Sorry, Galusha, Myers, Cooper.
I have 2.
And Floyd.
Okay. Okay, Floyd. These are continued?
Yes, sir.
Okay, so that's pages 14, 17, and 25 of the agenda. Were these continued at the county's behest, or did I?
The county.
Okay. All right, so for those of you who remain, I'm going to go ahead and give you kind of a speech, some things to remember as we go through this hearing. Good morning again. I'm Christian Waugh, a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this opening statement does apply to all of your hearings, so I'd appreciate it if you'd pay attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call the case, and I will allow the county to present its case. You will then have an opportunity to cross-examine any of the county's witnesses, and you will also have an opportunity to present your case regarding the violation. That would include your time to present any defenses that you wish. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask whether or not you are contesting the violation. If you do not contest the violation, then I'll assume that there's a factual basis for the violation and proceed to ask you how much time you need to fix it or to work with the county. This will help save time for yourself and others, but you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have 1 opportunity to speak per case. Such right to speak is not unlimited. Ma'am, could I just ask you to... Ma'am, sorry, if you don't mind, thanks. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county has the right to foreclose on that lien or to seek money judgment against you after the lien has been recorded for 3 months. In addition, if I find that the harm is irreparable, I may issue a one-time fine, and that will issue immediately as a judgment. There won't be a time to bring the property into compliance. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will also impose the costs required by county law. In other words, the county has a code section that says I have to assess the enforcement costs, the costs of the county actually bringing the case. I incorporate these into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you'll be responsible for additional costs, as well as the cost of the lien imposed. Let's see. You do have the right to appeal any order that I make today as may be provided by law. Thank you.
First case for no contest. Dale and Michelle L. Dew, case number 2026-121, Code Officer Alan Jonason, page 12 of your agenda.
Your Honor, I've been notified the parties spoke beforehand. They've agreed to 4 months as a time to cure and $100 a day thereafter if not brought into compliance.
I'm sorry, Ms. Harrison. Can you tell that to me one more time?
Sure. It's 4 months to cure and $100 a day thereafter.
Okay. Very good. Can we swear them in? Ma'am and sir, can you please state your names for the record?
Michelle L. Dew, D-E-W.
And Dale S. Dew.
All right, thank you, sir and ma'am. Good morning. Mr. Jonason, let me ask, what was the case about?
So it's a junk case, appliances, numerous appliances on the property, and they've agreed to abate 4 months or $100.
Mr. and Mrs. Dew, does that make sense? I mean, do you agree with the terms as presented to me?
Yes, sir.
Yes, sir.
Okay. Is there anyone from the public who wants to speak on this case? All right, then I will find that a violation exists based on the resolution. I'll accept the resolution based on what's been represented. I'll grant you 4 months to bring the property in compliance. That's a lot of time, so that's a really good deal. And just so the public is aware, the reason why we do these resolutions is because you may be getting a much better resolution by working with the county than by me actually hearing it and then bringing a hammer down. So I'll grant 4 months to bring the property into compliance, and it'll be $100 a day if you don't succeed.
Right.
All right, thank you very much.
Thank you. Thank you, folks.
Next case for no contest. Suzanne and Jane Fritchman, case number 2026-269, Code Officer Alan Jonason, page 16 of your agenda.
While they're approaching, the parties discussed this beforehand, and they've agreed to 60 days to cure and $50 a day thereafter if not brought into compliance.
All right, thank you. Sir? Can you state your name for the record?
My name's Jerry Harrell, wife Pam.
Pamela.
Okay, now we're here on case 26-269 for, it says here on my agenda, Suzanne Frischman and someone Jane Frischman?
Yeah.
Middle name.
Oh, okay, so you are the people,
My granddaughter and her husband, Sue, let them live there. She lives in West Essex Junction, Vermont. She's in her 80s.
okay,
And she had no control over anything that was going on at the
okay.
property.
I mean, then are you, so just to be clear for the record, are you owners of 1428 East Winnetka Street?
No,
No.
she
Okay.
is.
She is. Why are you here today?
It was our granddaughter and her husband that was living on the property
And you feel responsible?
and caused the violation. So I guess I'm gonna be the one that's gonna have to be responsible.
Well, we'll take that up, but unfortunately, I don't know if the county disagrees with me, but I don't think you have standing to represent the owners here and to come to a resolution with me. So I'm gonna have to call up the case later, and I'll hear from you as members of the public, but I don't think you have standing to represent the owners of the property here. Make sense? Okay.
Sorry, but I vote.
Sorry, guys. Thank you. No problem.
Next case, Joseph, Adam, and Sarah and Michelle Jorez, case number 2026-479, Code Officer Alan Jonason, no contest, page 21 of your agenda.
Your Honor, the parties spoke as a one-time fine for $5,000 on this case as a site modification, I believe.
Understanding that the maximum I can assess is 15,000, correct?
Yes, Your Honor.
Okay.
Yes, ma'am. Yes, ma'am. Yes, ma'am. Adam Jarris?
And I pronounce that Jarris?
Yes, sir.
All right, thank you, sir. Tell me a little bit about this case.
Yes, sir. So they have a lot adjacent to their property. It was completely cleared of trees and graded.
Okay, well, I mean, Mr. Jarris, we've seen these before. I mean, that's a reasonable resolution from my perspective, given, you know, the range of penalties that the county seeks here. But let me ask, you heard the terms of the resolution. It was the one-time fine. And I want to be sure you don't oppose that.
No.
You're willing to, you can see there's a violation. And
We cleared the lot. Well, my general contractor cleared the
yeah,
lot.
right.
Yes,
right.
sir.
Yeah,
So
you need to go after your GC.
that is what's coming up next.
I see, okay. Now, you're not the only owner of the property, correct?
So we had to put it in the same names as our house is under because our goal is to adjourn the lots, and that's the only way through county that they would allow that.
Okay,
My wife is working, I have time off today, and my parents are in a different county.
okay.
So
But are you aware of any reason they would oppose I mean, do you have authority on behalf of the owners?
to say reason, yes. Authority, yes. Like,
Okay,
we
that's
are-
what I want to make sure.
Yes, sir.
All right, is there anyone from the public who wants to be heard on this case? Okay, I don't see anyone, so I'll go ahead. I think there's a concession here on the record. I'll find that a violation exists, the lot was cleared, and assess the one-time fine of $5,000. All right, well, good luck.
Thank you, sir.
Thank you.
I appreciate it.
It's the first time in a while anyone's accepted responsibility up front for that, so that's remarkable.
Next, no contest case is Oak Avenue Development LLC. Case number 2026-316, Code Officer Julie Wilkinson, page 26 of your agenda.
Your Honor, for Oak Avenue, we again have an agreement of a one-time fine for $2,500.
Okay.
Yes. I do.
Yes.
Ryan Heinricher, Principal for Oak Avenue Development.
Okay, great. And what is your last name again?
Heinricher?
Heimricher.
Yes.
Okay.
Yep.
Well, and so, Mr. Heimricher, you represented that you have authority, I think, on behalf of Oak Avenue Development. Okay. And you heard the terms that were discussed right here on the record. Do they accurately reflect your agreement with the county?
They do. Special Master Law, we cleared the lot the violation was observed 8 days prior to the site plan being approved. My land clearing guys got ahead of things. That's on us. I accept the responsibility. I have a couple more we'll talk about later.
Oh, really? Okay.
Where,
We do? Like on today's?
yes, we're actually have the site
They're
plan
under different
approval.
corporation
That's-
names.
I see.
But-
Okay.
But this one, we clearly were in the wrong, and so
Okay.
I accept the terms.
Fair enough. Well, I mean, based on the facts, that sounds like why it's maybe 2,500 instead of more. So is there anyone from the public who wants to be heard on this case? I don't see or hear anyone, so I'll go ahead and find a factual basis exists. Again, remarkable. We have in the same hearing, two different parties conceding this kind of a case. It doesn't happen often. All right, so I'll enter the order. It'll be $2,500, and thank you for your candor.
Yes, sir. Thank you. Thank you, Julie.
Next case for no contest, Henry and Wendy Stauffer, case number 2026-414. Code Officer Jillian Nocella, page 31 of your agenda.
Your Honor, we're going 3 for 3 today. We
Wow.
have a no contest for a site modification at a one-time fine of $2,000.
do.
Wendy Stoffer.
Henry Stoffer.
Good morning, sir and ma'am. All right, so what are the terms? It was $2,000. Is this another site clearing?
Yes.
Okay, have you heard the terms as announced on the record?
Sir.
Do you agree or do you concede to them? All right. Is there anyone from the public who wants to be heard on this case? Is there anything else I need to know?
I don't think so.
Okay. All right, then I mean, that's fair enough. So I appreciate y'all coming. I will go ahead and enter the order, and again, thank you for your candor.
Thank you, sir. Have a good day.
Thank you.
We have some added no contest as well that I just became aware of.
Okay.
Franklin Preston Bishop, page 8 of your agenda, case number 2026-169, Code Officer Jillian Nocella.
Your Honor, I've been notified they've, parties discussed beforehand, and they're in agreement with 3 months to abate and $50 a day thereafter.
Hey. So help me God.
Okay.
Franklin Preston Bishop.
Okay. Thank you and good morning, sir.
Morning.
Did you hear the terms of the proposed resolution?
I did.
Okay. I mean, that's about as low a fine amount as the county has ever recommended. So
Appreciate it.
can you tell me a little bit about what's going on the property?
Yes, it's just for junk and debris. There was a mobile home on the property that unfortunately caught fire. It's just some debris left from
Okay.
the remains of the mobile home.
Okay. Is there anyone from the public who wants to be heard on this case? All right, I don't see or hear anyone. So I'll go ahead and accept the terms of the resolution, and I'll issue a written order stating that you have 3 months to bring the property into compliance. If it's not brought into compliance as ordered, it'll be $50 a day.
Okay, sounds good.
Thank you.
Thanks for making me clean it up.
Yeah, thank them, yeah.
Next case for no contest, we have Holloway, Dakota and Christopher Lee, case number 2026-297, Code Officer Robert Gennaro, page 18 of your agenda.
Your Honor, while the parties are approaching, I've been notified it's a no contest with 90 days to cure and $150 a day thereafter. It's not-
Dakota Holloway.
Good morning, sir.
Morning.
Robert DeNaro, Citrus County Code Compliance. Basically, this is an excessive accumulation of vegetation, a lot of trees and debris. Due to the burn ban, he just was unable to get rid of it, so.
Is the burn ban still in effect?
Yes, sir.
Okay.
So he's hoping that within the next 90 days that it will be dismissed and he'll have the opportunity to take care of the property.
Yeah, that makes sense. Is there anyone from the public who wants to be heard on this case? Burn ban's affecting a lot of folks. Have you heard the terms that have been announced on the record? Essentially 90 days. If it's not brought into compliance in 90 days, $150 a day?
Yes, sir.
Okay. And that's the terms you agreed to, I assume, with the county? All right. Then I'll go ahead and issue an order granting those 90 days, and if it's not brought into compliance within those 3 months, I imagine it'll get wet at some time during then. You'll be fined $150 a day. Okay, well, thank you and good luck.
Thanks.
Our last case for no
I'm sorry, did I
contest.
ask if the public, was there anyone from the public who wanted to speak on that case? All right, I didn't see anyone. Thanks, sorry.
And JC, I have 2 no contests still.
Do you? Okay. No contest, Shelley Johnson, case number 2026-260, Code Officer Alan Jonason, page 22 of your agenda.
Your Honor, as the parties are approaching, I was notified this was a no contest with 4 months to cure and $100 a day thereafter if not brought into compliance.
Yes. Shelley Johnson.
Sammy Johnson.
Okay, good morning, ma'am. I will just ask, I mean, it seems, I'm glad that you all are coming to resolutions. I think that's wonderful. But is it Christmas? No, I mean, I joke a little bit. I've never seen so many, and I think it's great that you are resolving it. Don't get me wrong. I'm just, 4 months is a really generous amount of time for any case. And sometimes, we always have to be reasonable, but, okay, I'll just put that on the record. It's a good deal for you. Now,
It's a big structure we have to remove.
it's a big structure,
Yeah,
okay.
it's-
What is the structure?
It's a 10 by 20 wooden shed with a shingle roof that has to be up on
Yeah.
skids, and we
Makes
have to
sense.
sell it.
And that's exactly the type of situation where you would get 4 months.
Yeah,
so.
we just bought the property 5 months ago because of the shed was so beautiful. And then, and then 3 months later, we get a letter from Alan,
Yeah.
like, oh, no. So,
I'll tell you, it's not the first time I've heard something like that or that's come in front of us, and maybe your remedies are against the seller, I don't know, but, that's the situation, so,
yeah, we had no idea.
yeah.
It was on it was on the appraisal website, so I saw it
Of
there
course.
and thought it was good.
Right.
The shed was there.
Well,
The taxes were paid.
consult a lawyer, that's my pitch, potentially self-serving. At any rate, the terms that I heard announced on the record were 4 months and $100 a day if not brought into compliance as ordered. Now, based on the size of the structure, I do think that's a reasonable amount of
We have to
time.
find a buyer for it. We have to sell it.
Okay.
I don't want to
I don't care
scrap it.
how it's happened, but it just has to go. So, is there anything else I need to know, Mr. Jonas?
No,
about the
sir.
property? Okay,
That's
you heard the terms that were announced on the record?
Yes.
All right. Is there anyone from the public who wants to be heard on this case? I don't hear anyone, so I will go ahead and issue a written order. We'll issue a written order, and it'll say you've got 4 months to bring the property into compliance. If it's not brought into compliance as ordered, there'll be a fine of about $100 a day. Good luck.
Thank you.
Okay.
Thank you, folks.
Thanks, Alan.
And I miscounted, so you're good to go.
Okay.
Next case on today's agenda, Francis C. Bass, case number 2026-587, Code Officer Cody McGuire, page 6 of your agenda.
Robert Bruce Germain.
Now, it does say, at least on my agenda, that the name of the owner of the property is Francis Bass. Who was Francis?
Frances Bass was my mother, and she's deceased.
Passed away.
She has been deceased for almost 5 years now.
Okay. And I assume you're an heir then?
Yes.
Okay.
Yes.
All right. Are you residing on the property?
Yes, sir.
Okay. All right. Then I will let the county present its case.
All right. Cody McGuire, Citrus County Code Compliance Officer. This is a repeat violation, initially served on April 27th, 2026. The address is 6959 West Arter Street in Christian River, Florida. Case number is 202600587. Accumulation of junk and debris. Violation of Chapter 20, Article 3, Section 2031A of the Citrus County Code of Ordinances. The property owner is Francis C. Bass, who has been previously found guilty of the same violation at the same location on May 20th, 2025. Case number 2025-00-130.
I was saying bless you.
Oh, sorry.
Sorry.
With $0 in imposed fines and administrative costs, and the case was abated on August 7th of 2025. I have good service via posting the property in at the Canto Government Building, and then I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is a finding of facts and an order acknowledging compliance from the previous case 202500130. Exhibit B is photos taken during my initial inspection on April 27th, 2025. Subsequent inspections on April 29th, May 1st, May 4th, May 11th, May 14th, and then my final inspection on the 18th. And then Exhibit C is a copy of the repeat violation, notice of hearing sent to Ms. Bass, a photo of the notice of hearing posted on the property, a copy of the general pre-hearing order, and a posting affidavit.
Okay. So he's going to show you the exhibits to take a look at. Let me know if you have any legal objections to them being evidence. if you want to look through them, you can.
No special master.
Okay.
It's all in.
Okay, all right, thanks. Well, let me just take a look at these real quick, because I vaguely remember the case, but not completely, so let me just take a look. Okay, all right, so I looked over the prior order. Let me look at the photos. I'll admit these as exhibits A, B, and C, but let me take a look at the photos. Okay. Okay, well, Mr. McGuire, please proceed.
All right. This property is at half an acre and is zoned MDRMH. I conducted my initial inspection on April 27th, 2025, and observed all the furniture, construction debris, loose trash, clothing, and miscellaneous junk. I posted the repeat violation that same day. I've had contact with Ms. Patricia and Mr. Robert when they seen the violation, and then my notice in the property, and then they abated it.
I was gonna say, by the end, by the last photos I see, it looks clean.
Yes, sir.
So what are the dates that you have evidence that it was in violation as a repeat?
April 27th through May 15th.
Okay, and so you were called out, and then you took a look on the 15th, and it was clean?
I was out there that Thursday, and then they only had a little bit to clean up, and I couldn't make it out that Friday, but that following Monday, I was able to go back out.
Okay. Do you hear anything that you disagree with?
We don't disagree with anything.
Sir, could you speak into the microphone? Let me get you into the microphone.
Special Master. We had a bad tenant, and he was doing a lot of bad things. He had robbed my shed, about $4,000 worth of stuff. The police say it's a civil matter, so he had the police at my house 27 times in a 2-month period, and he has not paid rent in 6 months. We have pictures of our own we took from the inside of the house, of the damage that he's done. I mean, he's trashed her house.
Oh, yeah.
Beyond, there's thousands and thousands of dollars worth of stuff. We both got hit on an e-bike on the 15th.
Of November.
And I had fractures to my T4 and my T11. She had compound fracture on her ankle. So
You were hit by the same e-bike?
We were on an e-bike.
Oh, you were on an e-bike.
We were
Yes,
hit
sir.
by a truck.
You were hit by a truck, gotcha.
Yes, sir.
So I can't tell you what we've been through because this guy has tormented her. She won't even stay up in her own house. I have an in-law apartment next to the house, and she's been staying with me.
Well, it sounds...
He had actually taken the sign that was put out front of the house.
The notice?
And hit it.
We found it in his room when he got arrested.
Yeah.
For animal cruelty.
Animal cruelty?
Yes,
Yeah.
sir. And he was also found to be a sexual predator that we did not know about, that had not registered.
What was the animal cruelty charge?
The animal cruelty charge was neglect.
What's the person's name?
John
Washington Bozeman.
I'm sorry, what is it?
John Washington Bozeman.
He's not in the home anymore. He's been gone for about
We had to go.
2.5
We
weeks now.
filed an unlawful.
Detainer?
We
Yep.
also filed a 3-day notice. We did everything that we could. I haven't been working, and it's just been an emotional roller coaster for the both of us. When we had the problem the first time, he had a lot to do with it. And the pictures that we have, we'd like to present to the court. That
Well, you can, but let me just ask you a question. So in the prior case, you're saying that the tenant was responsible in the prior case?
Yeah, and he had straightened up, and then when we wanted him to get out because he was on drugs.
He hadn't paid us in 6
And he hadn't paid us, and once he found out that we wanted him out, is when he started he busted all the windows out of my trailer. Started throwing all of his trash out the windows.
He hit me in the head.
He brought a couch up there. I mean,
Put his hands on her.
And you're saying he should be a registered sex offender, but
Yes.
did not register?
He
Yes.
did not register until there was another charge put against him.
So he is registered now?
Yes.
Yeah, that's
Okay.
the 25th.
The
We didn't know
25th
that
of what month?
wasn't
April?
Last month,
last month.
March, I think
Yeah, it
is
would be
when it was.
difficult to be for May. So,
We went to get paperwork to get, what was it?
The injunction for
We
when
went
he
for an
hit your head.
injunction when he hit me. And they gave me, I asked them everything that they had, you know, for my case and for us. And in the paperwork, there was a piece of paper that
Said he was a sexual offender.
somebody had said something to me about him, and my neighbor is a friend of his, and she told him to come and stay at our house before I got there. Long story short, I confronted him about it, and he lied to me, and my neighbor also lied to me.
he lied to you?
He lied to me.
It's the least bad thing he's apparently ever done in his life.
Oh, this guy,
well,
guy's something else.
Let me ask a few questions. So, Mr. McGuire, are you hearing anything that you disagree with or that you know is false?
Well, whenever I first got back in contact with them, that's the story that they had.
Well, did you ever meet this tenant?
No, when I first took my initial inspections, I had tried to communicate with him, but he just paid no mind to me, like I wasn't even there.
But, I mean, have you seen this person?
I'm only assuming it's the person that was in the front yard whenever I was
see.
there.
That's
yeah.
what I'm wondering.
Your Honor, I can confirm we do have a code case currently with John Bozeman. Give me a second to confirm the address I have on my petition.
Okay, that'd be very interesting to know. Just for my own knowledge, now, Mr. McGuire, you are listed as the code officer on the last case as well.
Yes, sir.
Did you have contact with Mr. Bozeman on that case, or did you see a tenant on the property at all?
I think I did, but I can't
Okay,
remember right
that's
off the top
fine.
of my head.
That's fine. I'm just curious.
And Your Honor, the address is the same.
It is the same. So there's a case against Mr. Bozeman
For the animal case, yes.
for the animal case.
Yes. And it is at this
Is
address.
this a public filing or public record, the case?
It will be when it gets signed today and filed.
Well, I just, maybe it's not relevant, but I'm just curious what the animal case is about.
He didn't feed his dog, and he was abusive towards the dog. And they had the dog pound up there a couple of times. And
tried
they
to
even
help him.
offered
Okay.
to help him with the vet and everything, and he would not get any
And
medical
let me
care
talk,
for
let me
his
say a
dog.
couple things. I'm gonna ask you to see the photos because I want to see whatever evidence you have to present, but I'm gonna tell you, I don't know that it's relevant. And the reason why I don't know that it's relevant is because what we're here today to determine, go ahead and show it to Mr. McGuire first, and we'll see if the county has any objection. Yeah, let's have the county attorney take a look.
That's inside the house.
I know, and you know, I'm not saying it's not gonna be interesting, but it's probably not gonna be relevant because we're here on a repeat violation for junk in
Yes,
the
sir.
yard. And we have a lot of cases like this where landlords rent the property out. It's not them junking up the yard, but you still end up responsible because of who you're renting
Right,
to.
right.
And so
I understand.
that's the issue, but what's the county's position on these photos?
Relevance, Your Honor. It appears to be the interior of the residence, a document from the sheriff's office, injuries sustained to the male individual present. And I think a crack pipe, but I
Okay.
could be mistaken.
You don't know what a crack pipe
Yeah.
looks like? All right, so I will, well, what I'm gonna do is I will admit for the purpose of mitigating damages. In other words, if these photos go towards the mendacity of the tenant and the fact that the tenant is responsible, more responsible than the landlord, let's say, then I would take that into account in assessing my repeat amount violation. So we'll admit them as Exhibit D, and I will just take a quick look.
Thank you, Special Master Law. Our only income right now is her SSI. I'm out of work, and I don't know if I can go back to work right now. I'm seeing doctors and stuff like that. I'm applying for SSI myself.
What's the county's recommendation?
$150 a day for 18 days.
That's right, and it's in compliance as of today.
Correct.
So, that's very low for a repeat violation. Is there anyone from the public who wants to be heard on this case? Well, guys, listen, I believe you. I mean, I think what you're saying is correct, and I have no reason to disbelieve it. You know, it's essentially argued with. The problem is I get these cases, and so I still have to issue a fine to deter landlords from renting to folks like this. And I mean,
Yes,
that's
sir.
part of the code, section. So I'm going to accept the county's recommendation, do $150 a day. For perspective, I don't know that I've ever done less than $250 on a repeat, but at any rate, that's going to be the fine amount. And I encourage you to try and get someone better in there if you can rent this.
I ain't gonna be renting to nobody.
Yeah, it's got to be cleaned up, but
It's a lot of work.
Yeah.
You know, and he systematically, he would turn our electric off at night.
It's wild.
I mean,
Yeah.
if you can see any of the police reports, I mean,
It's crazy.
we're more than embarrassed. Just
Well,
put
go
it
save
way.
that dog, and I wish you luck.
We both have dogs, and they're both registered and all that good stuff.
Yeah.
We're dog lovers, you know.
Good.
Broke our heart to see it sometimes.
Exactly. All right.
Thank you.
Good luck.
Thank you.
Thank you.
Next case, Empire Construction Management, LLC, case number 2026-068, Code Officer Julie Wilkinson, page 13 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Samantha Tillman.
It's
Samantha Tillman.
Tillman. And you are here on behalf of Empire Construction Management?
I am
Okay. Are you a principal or an attorney?
a
or-
manager.
Okay. All right, great. Thank you. All right, Ms. Wilkinson.
All right, good morning. It's case number CE 2026-00068, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 9944 North Wayland Way in Denellen, Florida. Property owner is Empire Construction Management, LLC. I have good service via posting the notice of hearing at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on January 21st, 2026, and aerials from the Citrus PA dated June 21st, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
So, ma'am, what we usually do is I ask her to show you the photos and or the other exhibits. If you have any objection to them being evidence, let me know. All right, then I'll admit them without objection. And just so I know, is there anyone from the public who wants to be heard on this case? Okay, all right, thanks. Go ahead.
This property is listed on the property appraiser's website as a vacant lot, 0.35 acres, and is zoned rural residential. I conducted my initial inspection on January 21st, 2026, and observed that the once wooded lot had been clear-cut, graded, and fill brought in. While researching the property, I found that there were no permits issued. On February 18th of 2026, a permit was issued for the property.
Okay, so there's a permit that's been issued.
Yes.
And normally, I'm just curious from my own perspective, do you issue permits when there is a site clearing code case still pending? Like it doesn't block you from actually issuing the permit? I think we've been in this situation before, I'm just curious.
It does not. We do charge a extra after the fact fee for tree removal, but otherwise, no.
I got you, okay.
We want them to abate.
Fair enough. All right, Ms. Tillman, you've heard the situation. Are you contesting whether or not there's a violation?
No, there is a violation, and I'm not opposed to that at all. I just wanted to explain, I mean,
Yeah.
We are a commercial builder primarily. We're almost at 300 houses in just this little community. We build houses in this community just because we enjoy this area and we want to build it better. What happened was the the permit was approved and issued through the old system, and we're used to that. So when we went to get it issued, the girls we had our weekly meeting, we figured out which permit we were gonna pull that week, and we notified everyone of what permit we were gonna pull. Well, when the girls went to go get the permit issued, then she learned that the permit had expired. And so when she learned that it expired, she reached out to the county to get it pushed forward. And whenever the county then said, well, we're not going to issue any more permits in the old system. We're gonna make you put it through the new system. Well, the person in the office did not relay that information to all the people in the field. Therefore, work had commenced. And as soon as the permit was finally issued in the new system, we pulled it and we just continued.
Gotcha. Ms. Wilkinson, do you have any reason to disbelieve what you've just heard? You do?
Ms. Coutu
Okay,
would like to.
yeah, I'm curious.
And disbelieve is the wrong word. I apologize for that. It expired in October. They resubmitted in January. We're not going to say, and you can't resubmit. Absolutely, we would have transferred it to the new system, which we did routinely. I'm not sure. I don't know her individual situation, but that's not something the county normally would do.
Okay. Well, let's see. Okay. I think, I've seen Empire Construction around. I'm trying to think. Have we had other cases? We have. Yeah, okay. Well, what's the county's recommendation?
A one-time fine of $5,000.
I didn't hear anyone from the public. Is there anything else from you, Ms. Tolman?
Not that I believe.
Okay. It's a third of an acre. Yeah, I think I'm just I'm gonna issue the $5,000 fine based on the facts of this case, and wish you luck.
Thank you.
Next case, Investor National Residential Capital LLC, case number 2026-315, Code Officer Julie Wilkinson, page 20 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
I'm sorry, which page? 20.
Excuse me, did you say 316 or 31? 315, okay. Okay. Case number 2026000315, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 9955 North Sherman Drive in Denellen, Florida. The property owner is Investor National Capital LLC. You have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 3rd, 2026, and aerials from the Citrus County Property Appraiser's website dated July 24th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, can you please show the documents and proposed exhibits? Let me know if you have any legal objections to them being evidence.
I have no objections.
And sir, can you put your name on the record, I presume as a principal of Investor National Residential Capital?
I do, sir.
I know he's sworn in. I need
Yes.
the name on the record.
Yeah, I'm the principal, thank you.
Your name?
You actually have to state it.
I'm
yeah.
sorry, Ryan Heinricher.
Thank you.
Principal for Investor Nation Residential Capital.
Perfect.
Yes.
Okay. Without objection, I will admit, I'll make them exhibits A and B as evidence in this hearing. And just for my own edification, is there anyone from the public who's going to want to be heard on this case? I don't see anyone. Please proceed.
This property is listed on the property appraiser's website as a vacant lot, 0.29 acres, and is zoned rural residential. I conducted my initial inspection on March 3rd, 2026, and observed that the once wooded lot had been clear cut and graded. While researching the property, I found that there were no permits issued at the time of the inspection. On March 19th, 2026, a permit was issued for the property. I have had contact with Mr. Milton, the contractor, and with Mr.
Heinricher.
That's what I have.
Okay, I mean, when you had contact with the two representatives, what was the contact about?
The contact with Mr. Milton was very contentious. He had claimed that he has submitted over 200 plans and none of them were ever denied, and that he clears his properties all the time without getting permits. He also stated that I was incompetent and I needed to get a new job.
Well, there are some counties where you may be able to clear your site without a permit. You know, Citrus isn't one of those places. Was this after you posted the violation, I presume?
Yes.
Okay.
Mm-hmm.
And what was the purpose? So did the contractor reach out to you?
Yes, he did. He reached out to a person in the permitting and the building department, and we had called him back together.
Was there a denied permit, or was it just not applied for?
I believe, I'm going to defer to Joanna to that, but I believe it was waiting for revisions.
Okay. Ms. Coutu, do you know?
So this was a fairly quick turnaround. They submitted on February 24th. They were issued on March 19th.
I see. Okay, so they had submitted at the time that the violation was noticed?
When was the first notice of the violation?
Because I see,
When did you first get that complaint?
I see a notice dated March 4th, 2026, notice of violation and notice of hearing.
Yes, that's correct.
Okay, so I just want to make sure, at the time you issued the notice of violation, they actually had an application for the permit? Pending, okay. Hadn't been issued. And, all right, and then tell me about your contact with Mr. Heinricher.
100% much better than my contact with Mr. Milton.
It was different.
Oh, yes.
Okay. Did he reach out to you or did you reach out to him?
He reached out to me.
Okay.
Mm-hmm.
Okay. I mean, that's all my questions for you. What's the defense?
So the defense is section 4002A specifically states, no development allowed by this code shall be established, changed, or altered. No building shall be used, occupied, or altered after the effective date of this code until there is first on file, approved by a official county action, a site development plan or preliminary subdivision plat for such premises. It does not state anything about a permit, and the site development plans were approved prior to the observed violation.
Okay.
On February 25th. So we have stamped site plans approved.
All right, do you want to introduce those into evidence?
Yes, sir.
All right, show them to Ms. Wilkinson and we'll see.
It's just kind of hard to see on the, you just need one. It's a little difficult to read because we're pulling it off the county site, and the new system is, it's just not, it's the second line down, which says zoning approval, 2/25. That's the date the site plan was approved.
All right, it'll be admitted as, well, are there any objections?
Sorry, I didn't look past page 1.
Okay.
That's just a copy of the site plan that was submitted. There's, the only stamp I could pull is that first page. So the, just to follow on, I had a good conversation with Julie, with Ms. Wilkinson, and, you know, I think the county's position was the intent is for permit, and I just read the code verbatim.
And you're saying, look at this code section, it doesn't say you
Permit.
can't, that, you know, it's not a permit, it's not a lack of permit code section, it's a lack of site development plan code section. And
Correct.
even the next sentence says, nothing herein shall relieve any applicant of the additional responsibility of seeking all permits, but that's not what this code section's about.
Correct.
I see. Do you have any other defense?
You know, and I have another case probably following this one, which is everything occurred on the exact dates. And then the other one that we spoke with earlier, that I basically give my site clearing guys a list, or Mr. Milton does, who's my hired general contractor, at my order, my responsibility. But they have a list, they're supposed to wait until we give them the green light, the one they got ahead. But we were going by site plan versus permit in this situation, just my interpretation of the code, or verbatim of the code, rather, not interpretation.
Just before I turn to the county, I'm just going to look something up in the code.
And I would say further, if the intent of the code is different, you know, I'm willing to go forward, obviously, and wait until I have a permit.
Well, just give me 1 second. I just want to do my due diligence.
Yes, sir.
We've had similar discussions on this code section before. Okay, what's the county's response?
He does not have a site development plan at the time. He had a zoning review approval, which is not, you can't leap that to be a site development plan.
Well, so what's been provided to me as
That's
the...
a zoning review, and it says at the top zoning review. That is one of about 10 people that review the plans. That zoning was approved at the time. Once you get a site plan development, that is part of your building permit issuance, but understood what the code says.
Well, it says, let's see, it says zoning review approved February 25th, preliminary inspection passed February 26th, addressing review February 25th, utilities review approved March 2nd. Is there no separate site development plan review for this?
That is part of the building permit. The building permit is the site development approval.
The building permit is the site.
Right.
So you're saying that under this code section, when it says a site development plan, it actually means permit?
In this case, yes. You know, if he would have got something that was issued that said site development permit or plan, perfect, but he didn't have anything issued at the time. He just had the reviewer say zoning review was approved.
Why wouldn't it say, well, what's an example of a site development plan that's not a permit?
There's not one.
So the county doesn't...
That's not true. I apologize.
The exception, I actually spoke to Ms. Coutu about this yesterday. The
Yeah.
exception is if you have an agricultural zoned and agricultural exempt
Yes, thank
property
you.
and you want to put your barn on your property, no permit required. You just have to do a site development plan.
Thank you.
And the county will stamp that as approved, and it's not a permit. So under those circumstances, you can have a site development plan without having a permit. Under residential properties or even building commercial properties, the site development plan and the permit coexist together, and they are issued at the exact same time. So a review of the zoning doesn't mean you have a site development plan approval. It means the county has reviewed it for zoning purposes, and it checks all the boxes.
Where in the code does it tell me that a site development plan is a permit?
They're not. They're two separate things.
'Cause why,
They
if-
run concurrent.
If what you're saying is true, why would it say in the next sentence, nothing herein shall relieve any applicant of the additional responsibility of seeking all permits required?
Correct, because, for example, the agricultural item, that doesn't require a permit. Zoning for residential does require the additional permit activity as well. So they are two separate things,
The
but
reason you have the agricultural exemption section is that, you know, there's these code sections that say the county has no business permitting those things. And that came after this code section was created, didn't it?
I am not sure about the
Not sure.
timeline.
She has a good example with agriculture, but she's correct in other ways too. For example, if someone wants to build a commercial stormwater permit, that would not be a building permit, that would be a site development permit. So there are other things. I'm sorry, I misspoke too fast there. You get up here and answer too fast.
No,
Sorry.
but I'm just, I'm wondering, you know, there's this idea when you read a statute that you follow its plain reading. And I understand there's the code section that says I have to defer to the land development interpretations if there's ambiguity, but it says site development plan. So what I'm trying to wrap my mind around is he's offered a common sense, what I would call a common sense reading. It says site development plan. Now, it could still be that the county's correct, even under his reading, to be honest, because I don't think I mean, I don't know that there is anything about a site development plan offered to me one way or the other. But I also don't know that it sounds like it's not required here. You know, so, well, in other words, where is the thing that says that a site development plan is a permit for residential purposes in the code? Why am I holding the word permit against an owner when it says site development plan?
In this instance, the permit and the site development plan run concurrent.
You're saying that, but what I'm saying is where in the code section does it say?
I would look in the definitions for development order and development permits
Yeah,
in chapter 1. That might be helpful.
So like the definitions in chapter 1, section 1500-ish? All right, let's take a look. The reason why I'm digging into this is because we have so many cases with this code section. I want to make sure that we're all on the same page. All right, site development plan is defined on page 1-44. It says the development plan for one or more lots or parcels on which is shown the existing and proposed conditions of the lots or parcels, including all of the requirements set forth in this LDC. It's not what a permit is. Is a site development plan required for this?
Yes.
Okay.
Yes. No, it's required to remove trees, which is what happened here, and he did not have that at the time.
Right, now I gotta be honest with you, I'm hearing a different argument. So what I wanna fully understand is, we now agree that it is not true that a site development plan is a permit under the code, correct?
There are two different definitions.
We agree
there.
now, so that's a difference. So we're gonna shift the last 10 minutes to the side. The issue now, I believe, is this code section 4002A says, no development allowed by this code shall be established, changed, or altered, and no building shall be used, occupied, or altered after the effective date of this code until there is first on file, approved by official county action, a site development plan or preliminary subdivision plat for such premises. Plat's not at issue. The question is the site development plan at issue? And I think it's uncontested. We're not really arguing about, there is no site development plan here, right? I mean, there's none in evidence. I don't have one in evidence.
The stamped site plan that he gets as part of a building permit issuance is his site development plan.
Okay.
When he gets that issued, it's part of it.
It's part of it. So I'm looking at other parts of it, right?
Right, the
So
various
there's
reviewers.
different components that have to be approved before the permit is issued.
Correct.
All right. So I think what you're saying is the site development plan is a component that needs to be approved before a permit is issued.
It's a part of the package.
Mm-hmm.
So it's one of the many things that has to be approved. It's not necessarily, well, I guess before, but it's part of the issuance.
Okay. Have they submitted one today? I mean, does the county have one on file?
The site plan that he's proposed and the stamp is the site development plan, yes. So that was issued in March, yeah.
Okay. When was it issued in March?
It was part of the building permit when that was issued. So whatever that permit issuance date is, that stamped
March
site-
10th.
It was on March 10th?
That stamped site
Yes, sir.
development plan in there, that site plan, yes.
Okay. Now, Mr. Heimricher, why don't I have a copy? Do I have a copy of that in here?
Of the permit, the full permit
No,
package?
the site, I guess the site plan or
So-
the site development plan.
The site development plan is, well, this is all I can pull off the county once it's submitted is the issue. Otherwise, you get the raw of what was submitted, which is all of this, and the very last page being the site development plan that zoning reviewed and approved. So that's the timestamp we've historically gone by.
You're saying the last
The last
page?
page, correct.
Ms. Coutu,
if you see it says site plan at
Yeah,
the bottom.
Is this,
That was-
can I ask you, hold on a second, Mr. Heimerker?
Yes,
So
sir.
I've got the last page here of this. I don't know if this looks like. And it does say March 17th. Yeah, but it says March 17th, reviewed for compliance. Okay.
That was by the building department, so zoning had reviewed and stamped that same item on February 25th.
Oh, really? Okay.
17th would have been the processing date, and the 19th was issuance date.
For
So
the
I'm sorry,
permit.
I want to hear from you, Mr. Heimerker. So where is the evidence that that was approved on February 25th?
Well, unfortunately, this is what we have from the county site.
Okay.
But it's the result of.
Oh, so you're
this-
saying this package was approved on the dates indicated at
Yes.
these levels?
Yes, and then the permit
Okay.
issuance is the very last
Okay, that makes
item.
sense. So now I'll
But
go back.
they actually had that site plan, and that's what zoning approved on February 25th. The document marked site plan.
Okay, so I think we're finally getting somewhere. I think that section in the code that says approved by official county action matters. And it sounds like what the county would tell me is that it would be the official county action has to be the permit issuance. I don't know, is that wrong?
The final approval of the site plan, which
Is
in
the
this case
official-
runs with, yes, the final approval
Right.
at all
That's the
levels.
official county
Yes.
action. In other words, it's not official county action for the code section that it passed an individual zoning review.
Correct.
Someone isn't entitled to rely on one component, although maybe this should end up being clarified in the code. But it's the approved by official county action is when, yeah, I mean, do you see where I'm going with this, Mr. Heimerker?
I see what you're going, where you're going, sir. I've been, and this is a different municipality, but I've been on the board of Winter Gardens. I've been the chair of the Architecture Review Historic Preservation Board. Each level of approvals is considered a county action typically in a municipal situation. So it's approved, the zoning was approved. That is a county action is how we're viewing that.
Yeah, I
understand
disagree.
how they're viewing
Yeah.
it differently.
I'm the city attorney for several cities, and it would never be considered the official action of the city until it actually went through all the steps.
That's
So
right.
I see what you're saying. This has been a very useful exercise for me in looking through this. I'm going to think about it just for a second.
And may I state one other thing? I think through the documents, I hope it's clear we're not just clearing land willy-nilly. That's not the intent.
Right.
I've built about 150 homes in Citrus County. I'm one of the few builders that saves trees we can save, often to my detriment. And so I care about those things, but I understand the county's perspective that they want everything 100% dialed in. We do not have that if we're talking permit being the official county action, and I understand your perspective.
That's where I'm headed. I mean, I'm not accusing you. I've seen a lot worse, of people willy-nilly, as you say, site clearing. And that's really what the county wants to deter. The fact that you had it in review, you've presented a new/old argument that I think has kind of been considered here before, but I've never had to go through that analysis. And I think it made us all actually look through every phrase of this code section, which I think has its own value. It's rare on these cases. So what was the county's recommendation?
Yeah, it's going to be a one-time fine of $5,000.
And I think that would be more appropriate if there wasn't something really in process. I understand how the contractor reacted, but it's hard for me to impute the contractor to the owner. So I'll assess a fine of $2,500 on this case. I'm sorry, but it is, I have to maintain the deterrent value is my perspective. So that'll be that on this
Thank you.
case.
Okay.
Next case, Investor National Residential Capital LLC, case number 2026-317, Code Officer Julie Wilkinson, page 19 of your agenda.
The address for this case is 9618 North Sherman Drive in Denellen, Florida. And property owner is Investor National Capital LLC, good service. via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 3rd, 2026, and aerials from the Citrus PA dated July 24th, 2025. Exhibit B, copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay, without objection, what's been proposed as Exhibits A and B will be evidence. Is this the same situation and argument?
Same situation, pretty much the same dates, so kind of right in the mix.
Have you heard anything you disagree with, Ms. Wilkinson?
No, sir.
Was the call from the contractor also about this property?
Yes, sir.
Was there a permit that had been applied for?
There was a permit, I believe that was also in waiting for revisions or in the process, but not yet issued. And I have that it was ultimately issued on March 19th, 2026.
Okay, is there anyone from the public who wants to be heard on this case?
I apologize, the dates are exactly identical.
They're exactly identical. Then I'll issue a fine for $1,500.
Thank you.
Thank you.
Thank you, Special Master. Thank you, Julie.
Your Honor, just to preserve the record, all the argument analysis done in the prior case is also applicable in this case for transcript or purposes.
Yeah, absolutely.
Thank
Yeah.
you.
Thank you all.
Next case, Lee Rivenbark, case number 2026-133, Code Officer Robert DeNaro, page 28 of your agenda. Expert on the case, Land Development Director Joanna Coutu. This case was continued from last month.
Okay.
Yes. Lee Rivenbark.
Welcome back. All right, so do you have anything else you want to present?
The only thing I wanted to present was the Exhibit C that Mr. Revenbach had presented to me in regards to the irrevocable unity of title affidavit. His property, he has 3 different parcels, they're 3 different addresses. When I made an inquiry with the property appraiser's office, he did unify 2 of the 3. The third one is the lot that he's in violation of. So he did do that, but he didn't do it. So it's lots 18, 19, and 20. 20 is not unified.
Okay. Is there anything else you'd like to?
Yeah, I have the new one from where it was.
Show the county whatever you've got and want me to consider.
This is the same thing.
No, that's the new one. That includes the third lot.
Okay. This is the new one.
Trying to remember the photos. Do you have the photos?
Yeah, I do.
Can you show them to Mr. Rivenbark, and then I'd like to look at them again. Ms. Coutu?
Yeah, so it's a unity of title, and he added another lot. Unity of title is for use. It would not help with tree removal or grading or anything. A unity of title is for a building permit. It's very specific for an accessory structure on a vacant lot. Filing it with the property appraiser and recording it is not going to change the fact they are separate lots of record. He cannot use, he can have a building permit for one of the vacant lots with this. That's really all this is good for, but I know you need to give that to
You can have a building permit for one of the lots.
Well, actually, if he wants to, both, because in this new unity of title, he did all 3, but unity of title and recording means nothing to us unless it's with a building permit. That's what it's for. It's not combining lots. What it's doing is saying, I want permission to go on this vacant lot and put an accessory structure because here's my house. Okay, it's with a building permit. There's no building
What would he
permit.
have to do in order to make it all one?
Right, replat.
A
He'd have
replat,
to
because
do
it's
a
3?
replat. Yeah, even so.
Because if it's 2, you don't do plats for 2.
We do
Really?
we do final plats for 2, yeah, or replats, yeah. There's not really a mechanism to combine them in Citrus County. We have subdividing exceptions, but we don't have combining exceptions, so it would be a replat or a final plat.
That's not what that states though, because, and that's, if you read it, and that's what it says is irrevocable, so then you forfeit the right to do a lot reconfiguration.
All right, let me take a look
Yeah,
at it.
he can do a lot of configuration if they're not platted lots. I apologize, that is one mechanism you can do.
Well, what I will do is, I've been presented a lot of stuff. So I'm going to admit exhibits A and B that were originally presented. I will admit, let's see, who labeled this exhibit C? Was it the county?
That was what he handed me initially on the last hearing.
Okay.
And then we introduced
Right.
it as C.
Okay, I just want to make sure. And then
Yes,
the
sir.
document I've just been handed, which appears to be the original. Is this the original document that you have given? Yes. Okay. And you've looked at it, the county's looked at it?
The titles, yes.
Yeah, okay. I'll admit it as Exhibit D. You know I have to take it. It is your original, but of course it's a public record. All right, let me just take a look at it. Well, the declaration may be irrevocable, but that doesn't mean anything. You can always split the things again. It's, the law says you can, so it doesn't matter what you say in a declaration. But I don't think that's relevant for what we're here for. So let me just take a look. Okay. Okay. All right. Let me just take a look again at the. Okay, so I guess I'm still, I wanted to give this argument a fair shake. What is the reason, why would this unity of title prevent you from having to get, go through the county for what you did on the property?
Because it was a backstop for shooting, and when I called first code compliance, and they said, no, we don't handle to find out if there's a permit or specifications for the backstop. They don't handle that. They said if there's a complaint for shooting, it goes to the sheriff's office. Could check with land development. When I talked with land development, they said there was no permit for a backstop. I talked to stormwater, and I talked to the sheriff's office, and when I called the sheriff's office, they said the same thing.
Meaning that you called everywhere you could think of, but you were told you didn't need a permit?
Correct.
Or any kind of
That
approval?
There was no permit for a backstop for shooting, is what I was told.
Mm-hmm. And it's the county, I mean, is there anything beyond that that's subject to this code violation from the county?
Your Honor, at this point, the violation is for the site improvement. Unfortunately, the question he asked isn't the violation he's being charged with. So his answers, I honestly don't know what his answers, if they were correct, because I wasn't part of the conversation, but.
Yeah, you're not a fact witness to that. Yeah.
But creating your backstop isn't why he has his violation. It's the land clearing, the moving, and things of that nature, which it doesn't sound like his testimony spoke to any of that portion of
Well, that's
the
why I'm
violation.
asking Mr. Nero. I mean, he's a fact witness. So what is the basis for the violation?
Basically, he altered the landscape, creating that, the violation of the site grading.
What is the site grading at issue?
Well, he just altered the, like I said, he altered the landscape to create that berm for his shooting.
He altered the landscape to create the berm.
Yeah, if you see the initial pictures, because it's grown over now when you look at it.
I mean, I see it. It's not. So, Ms. Harrison, you're saying that it's not the creation of the berm, it's the grading that was done to create it.
It's a distinct nuance. From what his testimony was, he called and asked, can I create a backstop for shooting? He didn't address whether the property was on a already developed residential lot, if it was on a vacant lot.
Yeah, that's what I'm asking.
So because it's a vacant lot, creating a pile of dirt, irregardless of what the use is a violation
that's what I'm
of the
asking.
section of code.
That's what I'm asking.
Yes.
Okay. She's right. In other words, you may have thought that it was enough to ask, what do I need in order to create this? And
Yeah, because, I mean, the dirt from the swimming pool that they permitted, in the site plan for the pool, it shows all 3 lots in the site plan.
but what the county's
So
position
they're
is,
saying because it's a separate lot.
yeah, but what the county's position is that on a separate lot or on any, frankly, any lot, if there's a change to the grading, if there's any kind of material change to the lot, and people can argue about what that is, but they've been very consistent in their position that site grading qualifies, that requires you to follow these code sections. And I mean, in this case, it says 4915 site grading permit, although it says, I mean, that's actually interesting. So on the notice of violation, it says 4915.
4915.
So 4915, a site grading permit can be issued for any lot of record. The applicant shall provide a site boundary survey, proof of ownership, existing elevations on the site, and proposed grading plan showing proposed elevations. I mean, it's not what it says on the agenda, but I don't know that that matters. I'm curious, well, why, Mr. DeNaro, it's interesting. So it's listed as, why is it listed on the agenda as 4002A, but you cited 4915?
I don't know. I didn't create the agenda.
Okay, no, I think,
yeah.
It's interesting to me because I'm gonna look up the code section real quick. I mean, 4915 seems like a better fit for it, but
That's what I cited.
a site grading permit can be issued for any lot of record. The applicant should provide on the site and proposed grading plan. Have you applied for a permit while this case has been pending?
No.
Okay.
I don't know
Okay.
what permit that would be. They told me there's no permit for a backstop.
Well, that's not at issue. Again, it's the site grading is what they're claiming is the issue here. Would you like to see it? I mean, I can give it to you. Yeah. What's going on?
No, for some reason, my computer's not cooperating with me. So
Okay.
unfortunately, I was just trying to get an extra copy from him.
But why does it matter for you? Whether it's 4915 or 4002?
Because I want to make sure I'm citing the same right law when I'm talking to you, because I was going off of the
Oh, well,
agenda with 4002.
I'm not concerned. I mean,
Okay.
I think my concern would be does it change the county's analysis if it's 4915 as to whether or not it's irreparable?
No. It does not.
Why?
Because at this point, once they've changed the topography of the land and we're dealing with grading, we can't put it back to the way it came.
But what if it's permitted? I mean, what if he can get a permit for what he did? Why would it matter?
I believe as part of the permit, and Joanna, correct me if I'm wrong, don't you have to show what it currently is and what you want to change it to? And since it's already been changed, he can't do that? Or am I incorrect in my thinking?
That's typical. It's typical that once you've changed it, it's hard to put back. Possibly an engineer could do that, but I agree, it's difficult. Once you've done it, you've done it. It's
I agree with that.
like digging a hole or whatever, yeah.
I mean, I kind of agree.
However, Your Honor, at this point in time, I will concede that the notice of violation that code issued does give him the option of obtaining the permit, so it would not be a one-time fine, it needs to be a daily fine. We would concede
That's
that.
my only concern here.
May I approach?
Yeah. That's my only concern. Thank you. Would you all like to confer about what you recommend, or are you prepared to make a recommendation?
I agree with counsel.
Okay.
If we could have a few moments to confer, Mr. Charlton and
Mr. Rivenbark, what I'm going to do is I'm going to call your case back up in a few minutes when the county's prepared to proceed. What I'm asking, does it make sense what I'm asking them for? It may or may
No,
not.
sir.
Okay, so the county originally it was proceeding under 4002A, a code section talking about material changes and all that kind of thing. And normally what they ask for is a one-time fine. But based on what you were cited for, they're going to consider whether or not they can have me say, well, no, I'm going to give you X days to bring it into compliance and no fine will be assessed, so you have enough time to go get the permit for the site grading. And you may not get it, I don't know, but that would give you a time to comply before the fine begins. Does that make sense?
Okay.
I'm going to let them talk about it. Well, maybe they're going to be prepared to proceed quickly, so.
I think we
Do
may
you
need
know
to
any
go
good
to the
jokes?
next
Do you know
case,
any good
Your
jokes?
Honor.
I don't either. That's okay. It's better than continuing it again. I hate to make you all keep coming back.
With the section that was cited, a daily fine would be
Okay, but what is your recommendation on the daily fine?
$50 per day.
Okay. How much time do you think you would need, Mr. Rivenbark, to apply for a site grading permit? Do you know?
I'm not sure.
It's
how long
not
it
something you
takes.
contemplated. Do you know how long this process normally takes or what is required as part of the plans?
I do not know what
Okay.
that is. I
Ms.
don't have
Katu,
the
do you
answer.
know?
Depending on the height, it may require an engineer involved, it may not, I'll have to talk to Pet Tech Services. I think 60 days might be pushing it a little bit, I think 90 is probably a lot more realistic.
Okay, I do too. Now, I have another question for the county. If he got rid of it, would that abate the violation? Okay, here's what I'm going to do. I'm going to issue an order that does find the property to be in violation of this code section, 4915. I'm going to grant you 90 days to bring the property into compliance. You can bring it into compliance one of two ways. Either you can get the site grading permit, okay? And I encourage you to talk as fast as you can to the county about what's needed for this. Because what they're saying is it may be that you have to have an engineer, depending on the height of it, okay? The second way to bring it into compliance is to get rid of it and to return the property to the way it was. And then there won't be a fine. Call the county, they'll inspect it, and then you're done. Does that make sense?
Yes.
Those are the two options. Do you have any questions? And you can appeal my order. That's the number 3 option you have. You can appeal it, say I'm wrong, and that's an option you have as well. Okay?
Okay.
All right, I'll issue that order. 90 days, $50 a day. If not brought into compliance, we're good to go.
Thank you.
Thanks.
Next case, Eloise Siobhan Lay, case number 2026-0188, case Code Officer Alan Jonason, page 23 of your agenda. Expert on the case, Land Development Director Joanna Katu. No expert on this one, sorry.
Okay, and I'm sorry, what page was this? All right.
Lee Jim. Yes, ma'am.
Yes. Eloise Lay.
Brian Van Dyke.
Okay, good morning.
Good morning.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2026-00188, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address of the violation is 4031 North Blue Water Drive in Hernando, Florida. Property owner is Leigh Eloise Chavon. This property is approximately 0.10 acres and is zoned CLR-MH and was purchased 1 June 2014. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 10 February 2026, photos from my compliance inspection on 3 March 2026, and photos from my final inspection conducted on 18 May 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, a copy of the pre-hearing order, and a copy of the property appraiser.
All right, can you take a look at these documents? No issue, okay.
The reason.
Are you contesting that there's a violation?
The reason why, no, I'm just explaining. The reason why I was living in Ocala, I'm now back in Citrus County. All this was stolen from my house in Ocala. And the sheriff's department, when they discovered it here in Citrus, made me pick it up and bring it to the house. But here's the thing, they stole everything I own. I have no titles, no registrations, no nothing to any of them. So I didn't know what to do. Working with Deputy Titus here in Citrus County and the Marion County detectives up there, they asked me to come here today to see if you could order the titles from the motor vehicle. I got rid of one. I sold one of them to a gentleman I knew, but the other one I just sold yesterday without a title, and now he doesn't want to take it until I actually have a title. I have 2 trucks that need titles.
So let me actually hear from Mr. Jonason before I get to, I don't even know what the case is until I let him talk.
Nobody does.
Well, no, I think I can see from the photos, but I want him to explain it to me.
Yes, sir.
Please proceed.
On 10 February 2026, I conducted my initial inspection and observed the property to be in violation of unlicensed vehicles. On 10 February 2026, a notice of violation was issued for unlicensed vehicles, which is a violation of the ordinance I mentioned earlier. On 3 March 2026, I conducted a compliance inspection and observed that the property remained in violation and a notice of hearing was issued. I have had contact with the property owner, and as of my final inspection on 18 May 2026, the property remains in violation.
Well, tell me about your contact.
So I believe I spoke to this gentleman. He indicated that the vehicles were stolen, they were wrecked, and they were returned to him by CCSO. That's okay. And I just explained to him that they still had to be removed from the property. They couldn't remain there.
Yeah, and I mean, it looks like you started this case over 3 months ago.
Yes, sir.
So it's been several months.
We fixed 4 out of 5. Dr.
Yeah, I can see the improvement. Right. I mean, would you agree that there's been improvement? But still, that's a long time for a case like this.
Well, here's the thing, sir, is that I had no documentation. I had to get everything redone, and it's been taking some time.
I understand.
It's very
vehicles weren't in his name yet.
Right. It wasn't even transferred to my name yet, so that's why I couldn't do anything with it.
It appeared, well, so to answer one of the questions you raised earlier, I can say whatever I want, but I don't know that the DMV has to listen to me at all. I don't think so,
that's
to be
the problem, is that
candid.
The 2 vehicles that I'm having trouble with, I can't get the titles for.
Well, I also don't have any evidence. It's really not for me to determine who the owner is. All I can tell you is there's an unlicensed vehicle here. It's got to go. And from the county's perspective, I don't know that I care where it goes. It's in violation of the code. You've already had 3 months.
Let me ask you a question. The one that's wrecked, I mean, bad. We got rid of it yesterday, but they picking it up.
Where did it go?
They're supposed to pick it up today.
Okay, so it's not gone.
A tow company.
Well, they already paid for it for junk. Okay. And they said they didn't have time last night to pick it up.
Okay. Right.
But they're coming back today between 2 and 3.
It's scrap. It's going to be scrap.
It's the blue one out by the road, yeah.
And now, the truck that's remaining is
a red one. And he worked on it,
Red one?
It's a blue one. It's
blue.
They're both blue.
Dark blue.
What she's trying to explain is that I have 3 trucks that were stolen, only one of them was in my name, the one I was able to get rid of. The other 2 are not in my name. That's why they're having trouble getting me paperwork on them, because they were not registered to me yet.
How much time do you need to get rid of this truck?
30
Only got
days.
one left.
30 days.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate these violations. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, here's the deal. I'm gonna give you 30 days, but the fine is gonna be higher than that if it's not off there, just because of the age of this case. So I'm gonna grant you 30 days to get rid of it. If it's not out of there in 30 days, $250 a day. Is there anyone from the public who wants to be heard on this?
Well, he's supposed to pick it up today or tomorrow, so.
I don't see anyone, so good luck. All right.
Thank you.
Thank you.
Next case, David and Tammy Rose. Case number 2026-0293, Code Officer Julie Wilkinson, page 30 of your agenda.
I do. David Rose.
Good morning, sir.
Morning.
This is a repeat violation initially observed on February 27th, 2026. The address of the violation is 67 South Lee Street in Beverly Hills. The case number is CE 2026-00293, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner is David and Tammy Rose, have previously been found guilty of the same violation at the same location on April 17th, 2025. That case number is CE 2025-00204. That case was abated on April 18th, 2025, with $0 in imposed fines and
It was
administration.
abated in a day?
Yes.
Wow.
I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, findings of facts and order acknowledging compliance from previous case CE 2025-00204. Exhibit B, photos taken during an initial inspection on February 27th, 2026, and photos from subsequent inspections on March 4th, 10th, 13th, 20th, 27th, April 7th, 10th, 17th, 21st, May 1st, 8th, 15th, and the final inspection on May 18th, 2026.
It seems well documented, whatever this is, so, okay.
Okay, Exhibit C, a copy of the repeat notice of violation and hearing, a photo of the notice of violation and hearing posted at the property, and a copy of the general pre-hearing order, and a copy of the posting affidavit.
Okay, sir, can you take a look at these documents and let me know if you have objections to them being evidence here today?
No, we're good.
Okay. Thank you. Without objection, what's proposed as Exhibits A, B, and C are admitted, and I am just going to take a quick look. I normally remember. Okay, please proceed.
This property is this property is a single-family residence. It's 0.21 acres and is zoned medium-density residential. I conducted my initial inspection on February 27th, 2026, and observed loose trash, household items, furniture, miscellaneous junk, and debris on the property. I posted the repeat notice of violation and notice of hearing on the property on March 4th, 2026. And I conducted follow-up inspections every week, and the property remained in violation until the inspection conducted on April 21st, 2026, when the property came into compliance and remained in compliance until the final inspection on May 18th, 2026.
Okay, so on the May, what is in violation from the county's perspective as of May 18th?
Nothing, it's in
Oh, you're saying it
compliance.
remained, it's not until it fell out, it was until your last inspection, it was still in compliance?
Yes.
That's, okay, got it.
Yes.
And so that's the way I kind of see it in the photos as well. Mr. Rose, are you contesting that there was a repeat violation here?
No, sir.
Okay. Do you have anything that you want me to consider in assessing what the fine would be from the date that it fell out of compliance until the day that it was brought into compliance?
This was, April 30th was the second year of the anniversary of my wife's death. So I cleaned out a storage shed, and that's what all that junk was.
Okay.
So I'm working through all that crap.
Okay. I'm just thinking about it.
The first violation was from the boys.
Okay.
My sons were over anxious with their new cars and had too many cars that were not licensed and tagged.
Okay. Yeah, I don't actually remember the original violation very well. Is there anyone from the public who wants to be heard on this case? What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative costs to begin on the date of the posting of the property, March 4th, 2026, and continue until April 20th, 2026. That would be 48 days at $150 per day, totaling $7,200.
Yeah, Mr. Rose, I mean, I think that is reasonable. It's still a low fine for repeat violation. The problem with having one, just that first case, is that the second time it happens, this happens. So it'll happen again if it happens again, except the fine amount won't be 150. It'll be even more. It'll probably be 350, 450. But for this, I'll accept the county's recommendation and find that there is a repeat violation, assessing a $150 fine for the days that it was out of compliance.
Thank you.
Good luck.
Next case, Suzanne and Jane F. Fritchman, case number 2026-0269, Code Officer Alan Jonason, page 16 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2026-00269, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31, A of the Citrus County Code of Ordinances. The address is 1428 East Winnetka Street, Hernando, Florida. Property owner Frischman Suzanne and Frischman Jane F. This property is approximately 1.2 acres and is zoned LDRMH and was purchased 1 August 1995. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 25 February 2026, photos from my compliance inspection on 30 March 2026, and photos from my final inspection conducted on May 19th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the posting affidavit, a copy of the pre-hearing order, and a copy of the property appraiser.
Okay. Without objection, what's been proposed as Exhibits A and B are evidence. Is there anyone from the public? Well, this is the case where I do, not yet, but I'm glad you're listening. All right, please proceed.
Yes, sir. On 25 February 2026, I conducted my initial inspection and observed the property to be in violation with large amounts of tree debris at the front of the property. On 25 February 2026, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance mentioned earlier. On 30 March 2026, I conducted a compliance inspection and observed that the property remained in violation and a notice of hearing was issued. I have not had contact with the property owner, and as of my final inspection on 19 May 2026, the property remains in violation.
I do want to hear from y'all now. Why don't you come on up, and I'd love to hear what you have to say. You've already been sworn in, so.
Still sworn.
You're still sworn, and I'd like to hear from you. What do you want to tell me about what's happened here?
Miss Sue Frischman lives up in Virginia right now.
No, Vermont.
Vermont. Excuse me. Anyhow, my daughter and granddaughter had an agreement with Miss Sue that the kids could live on the property, pretty much minimum rent to rent-free, as long as they kept the property up and kept everything in order. Apparently, my granddaughter's husband allowed a tree trimming company to dump off some wood that he was supposed to saw up for lumber to make chicken coops out of. But that got out of hand, and it was more than just usable wood he could saw. I was called. Let me rephrase that. They decided to go off the grid and try to live the old-fashioned way without electricity, and they used a lot of the wood for fires and cooking, heating, wintertime. Anyhow, the place got a very, very disarray or a mess, so to speak. It needs to be cleaned up. I intend to clean it up. My son said he would help me, and my granddaughter's father will also help me get it cleaned up. I spoke with Mr. Jonathan.
Yes, sir.
And he said that it needs to be cleaned up. We agreed, and I'll work with him. Whatever he says needs to be done will be done. I'm asking for an extension to give me time to get it done. I was only notified of this, violation a week and a half.
How did you find out?
I think my granddaughter went up and saw a notice on the property. She did not do any mail forwarding or anything when they split up, in the process of the divorce right now. So I'm just asking, pleading at least, for an extension where I can give me time to clean it up.
I'll give you time, but what's the plan?
Whatever, Mr. Johnson.
Well, I mean, look, I don't know what Mr. Johnson would say, but I can tell you that what I'm going to find is that there's a violation. And I'm going to say you need to abate that violation within X days, whatever number that is. And what it really means is you've got to get rid of it.
I'll bring the property into compliance.
And that's what I mean. What is the plan to get rid of it?
I believe there's a landfill on 41 between Holder and the property. If not, the county landfill is available. I have a diesel truck with a dump trailer, gooseneck dump trailer.
This stuff is pretty, I mean, it's a lot, and it looks heavy. It looks big, it looks heavy, so some of it might need to be chopped before you...
He was making money off of this. They were paying him, our granddaughter's husband, $50 a load, and he was making money off of that.
I was not aware of that.
Yes, and she had nothing to do with it. She tried to get it stopped, and he just continued to do it. And he doesn't have...
Should have charged more than $50 a load.
Well, that's what I understand, that the people were paying him to take the load.
Okay. Is there anything else you want me to know?
Yeah, I'm just asking for some time to get it done, and it will be brought into compliance.
Okay. Thank you.
Thank you, sir. God bless.
God bless. Mr. Jonathan, is there anything else you want me to know?
Just that we had a prior discussion before, and we were going to expedite it. He initially asked for 30 days, and knowing how much is there, I said, would 60 help you out more? He said yes. And I also agreed to a $50 a day fine after that. So $50 a day.
Okay.
And 60 days.
Okay. I don't see anyone from the public besides y'all, so I'll go ahead and issue that order. I'll find that there's a violation, grant 60 days to bring it into compliance. But if it's not brought into compliance as ordered, a fine of $50 per day will accrue. Okay? Good luck.
Thank you, folks.
Next case, Ashley N. Bays. This case abated late yesterday afternoon. I just wanted to let that know for the record. So that case is being taken off.
You're taking it off?
Yes, it
Okay.
abated
All right.
late yesterday
Tough
afternoon.
deal.
Jack and Charmaine Beasley, case number 2026-0111, Code Officer Alan Jonason, page 7 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2026-00111, unlicensed and operable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. This property is approximately .22 acres and is zoned CLR and was purchased on 1 October 1999. Address of the violation is 3668 East Delight Street, Hernando, Florida. Property owner is Beasley Jack and Beasley Charmaine. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 28 January 2026, photos from my compliance inspection on 2 March 2026, and photos from my final inspection conducted on 19 May 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the posting affidavit, a copy of the pre-hearing order, and a copy of the PA.
Okay. Without objection, what's been proposed as Exhibits A and B are admitted into evidence. Okay. Go ahead.
Yes, sir. On 28 January 2026, I conducted my initial inspection and observed the property to be in violation of unlicensed inoperable vehicles. On 28 January 2026, a notice of violation was issued for unlicensed vehicles, which is a violation of the ordinance mentioned earlier. On 2 March 2026, I conducted my compliance inspection and observed that the property remained in violation and a notice of hearing was issued. I have had contact with the property owner's daughter, and as of my final inspection on 19 May 2026, the property remains in violation.
What did you learn from the contact with the owner's daughter?
So she called me on 4 May 2026 indicating, I had a junk case as well. They cleaned the junk case up. They cleaned that up. It looks like they did make an attempt to put the vehicle back together, but
Yep.
it is still on jack stands and obviously is inoperable.
It looks that way. I mean, it looks like they kind of affixed a donut tire,
Yes, sir.
like
Yes,
to the
sir.
front.
And it's still on jack
And
stands.
it is still on jacks. Okay.
Lights missing.
What's the county's recommendation?
$100 per day.
Okay, then I will grant 14 days, and if it's not brought into compliance as ordered within 14 days, $100 a day fine.
Thank you.
Yep.
Next case, Charles Krantz, case numbers 2026-0420 and 0431, Code Officer Robert DeNaro, pages 9 and 10 of your agenda.
Robert DeNaro, Citrus County Code Compliance Officer. These are 2 cases I put together. Case number 2026-0042, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code Ordinances. And case number 2026-00431, unlicensed and operable vehicles, violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address in question is 6696 East Mark Road, Floral City, Florida. The property owner, Charles Krantz. Good service via posting of the notice of hearing at the property in the Lecanto Government Building. I like to authenticate the following documents and request they be admitted into evidence. A, photos taken during my initial inspection on March 24, 2026, corrective action inspection on April 8, 2026, and photos of my final inspection on May 18, 2026. Exhibit B, a copy of the notice of violation, copy of the notice of hearings, a copy of the notice of general pre-orders, a photo of the notice of hearing posted at the property, and the posting affidavit. This property is a single-family residence. That's 2.02 acres. It's zoned RURMH. On 2024, I conducted my initial inspection, and found furniture, tools, garbage bags, and miscellaneous junk and debris throughout the property, as well as a number of inoperable, unlicensed vehicles on the property. On March 24th, 2026, a notice of violation was issued for junk and debris and unlicensed vehicles. On April 8th, I conducted my corrective action inspection and observed that the property had remained in
Wait,
violation.
when did you first go to the property?
March 24th.
And you issued the notice of violation the same day?
Yes, once I noticed it, yeah, March 24th, and then I issued both the notice of violation for the unlicensed and the junk and debris. Yes, sir.
Did you give them a time to comply before issuing the notice of violation?
Yes, they had till April 8th.
Okay, gotcha.
Right,
Perfect.
this is my
Sorry,
corrective
that's what I'm
action.
trying
Yeah,
to-
yes, sir, I'm sorry if you
No,
misunderstood
you
me.
didn't. It's my misunderstanding.
Okay,
Yeah.
gotcha. On April 8th, 2026, I conducted my corrective action inspection and observed that the property had remained in violation. I've had no contact with the owner, and as of my final inspection on May 18th, 2026, the property remains in violation.
Now, your exhibits A and B, are they the same exhibits for each case, or are they different?
They are the same because but I separated the two because they were two separate cases,
Okay,
obviously.
fair enough. So without objection, I'll admit exhibits A and B in each case. I don't see anyone from the public and therefore won't be asking if there's anyone from the public, although hopefully we've got a lot of great viewers. Let's see. All right, let me look at these exhibits briefly. It looks like a good-sized property, as you said.
Yes, sir.
Ooh. Wow. Okay, what is the county's recommendation in each case?
Well, each case, I'm asking for $150 a day per violation and administrative cost, and the date that you deem sufficient to abate the violation.
And you have not had contact with the owner, correct?
No, sir.
Well, not having the benefit of any defense or explanation, I will require a compliance within 14 days in each case, and if it's not brought into compliance as ordered, there'll be a fine of $150 for either one.
Yes, sir. Thank you.
Thanks.
Next case, Rodney Daniels Jr., case number 2026-0048, Code Officer Julie Wilkinson, page 11 of your agenda.
I apologize. Which case is this again?
Daniels?
Okay. Yes. Case number 2026-00048. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5 West Murray Street in Beverly Hills. Property owner Rodney Daniels Jr. I have good service via posting the notice of hearing at the property in the Lecanto Government Building. I would like to authenticate the following documents and request it be admitted into evidence. Photos taken during an initial inspection on January 16th, 2026. Photos from a corrective action inspection on February 25th, 2026. And photos of my final inspection conducted on May 18th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and photos of the notice of hearing posted at the property, and a copy of the posting affidavit.
Thank you. Exhibits A and B are admitted as evidence. Please proceed.
This property is a single-family residence, 0.14 acres, and it's zoned medium-density residential. On January 16th, 2026, an initial inspection was conducted, and I observed discarded furniture and miscellaneous junk and debris on the property. On January 16th, 2026, a notice of violation was issued for the accumulation of junk and debris. On February 25, 2026, a corrective action was conducted, and the property remained in violation. As of the final inspection on May 18th, 2026, the property remained in violation. I have had contact with Mr. Daniels. He expressed to me, he has a junk hauling business, and he expressed to me that he was having difficulties getting rid of the junk, and it was going to take him time. He has slowly made progress, and there's just a little bit left to do.
Yeah, there's not a whole lot. It's kind of surprising. All right, what's your recommendation?
$50 a day, along with the administrative costs, beginning after the date you deem sufficient.
Okay, 14 days, $50 a day.
Thank you.
Thanks.
Next case, Forterra Realty LLC, case number 2026-0482, Code Officer Julie Wilkerson. Page 15 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Have we had Forterra Realty before?
Maybe a different code officer, but I don't remember taking one.
Okay.
The address, this case number is CE 2026-00482, violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. The address is 9104 North Bermany Way in Denellen, Florida. Property owners, Forterra Realty LLC. You have good service via posting the notice of hearing at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on April 7th, 2026, and aerials from the Citrus PA dated July 17th, 2025. Exhibit B, a copy of the notice of violation and notice of hearing, and copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Okay, without objection, what's been proposed as exhibits A and B are evidence. I will take a look. Please proceed.
The property is listed on the property appraiser website as a vacant lot. It's 0.23 acres, and it's zoned rural residential. I conducted my initial inspection on April 7th, 2026, and observed that the once wooded lot had been clear cut. While researching the property, I found that there were no permits issued. On April 18th, 2026, a permit was issued for the property. I have not had.
When was it issued? May 11th.
I apologize.
I'm sorry, it was ready to issue on her date, she's correct, but I
Gotcha.
didn't actually pick it up until May 11th.
Gotcha.
Sorry
Okay.
about that.
Okay.
I have not had contact with the property owner.
What's the county's recommendation?
$5,000.
Okay, I'll assess it.
Thank you. No, you're okay. You're good.
And just for the record, find that there's a violation. It's very clear from the exhibit.
Next case, Kari Millen, case number 2026-0128, Code Officer Cody McGuire, page 24 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
I only have one of them. Ready?
Yep.
Cody McGuire, Citrus County Code Compliance Officer, case number 2026-00128, animals and animals as pets, a violation of section 3730 A and B of the Citrus County Land Development Code. The address is 11458 North Jenny Lane Point in Inglis. It is zoned CLRMH and it's a half acre. The property owner is Carrie Millen. Good service via posting the property and at the Lecanto Government Building. And I'd like to authenticate the following documents and request they be admitted into evidence. Photos taken during initial inspection on January 27th, 2026. Corrective action inspection on March 27th. Subsequent inspection on May 11th. And photos of my final inspection on May 18th of 2026. And Exhibit B is a copy of notice of violation, copy of notice of hearing, photo of the property posted, a posting affidavit, and a general pre-hearing order.
Okay. Without objection, the proposed exhibits are evidence. Go ahead.
So this one's like an animal pen, and the animal, she started out with fowl, a pig, and other animals. She's recently down to the chickens. She just has to remove the pen 10 feet off the property line.
Okay, hold on. So the initial case had to do with the owner caring for and maintaining awesome chickens.
Chickens, geese, and a pig.
Okay, chickens, geese, and a pig, or more than one pig?
I only seen one pig.
And did you have contact with the owner at that time?
Not during my initial inspection. Once she received my violation, she worked on removing the animals. The only thing that she asked for was just a little bit of time to bring the pen or the coop just off the property line.
Where did the chickens, geese, and pig go?
To another home in Crystal River.
Okay.
Yes.
Okay.
Yes, not all of
Okay.
them. Just the animals that she wasn't allowed.
Okay. So wait, what's the violation at this point?
Right now, the chicken coop is currently too close to the property line. It's right against the backside.
How is that a violation of these code sections?
It's got to be 10 feet away.
Okay. Maybe it's not on the agenda, but. It's not. Okay, let me look at your
Unfortunately.
notice. Sorry, Ms. Harrison?
Unfortunately, it's not on the agenda. It's buried down.
I see it, okay. Wait, you are gonna have to help me, actually.
If you go to 3730,
Mhm.
and go into subsection B, animals as pets, which is what she qualifies for under with the chickens that she has. And then you go down to sub 5, any coop, pen, or other similarly utilized structure shall be located no less than 10 feet from the property line.
I'm familiar with that rule, I just didn't see it in the, let me just check it out. There's a lot of pages in this one.
3-92, I believe, is the one it's on my page. So you might be a page or two off of that.
How close are they to the property line?
They're right against
on
it. She plans on like decommissioning the 2 other sides of the coops, and then using that for the back to bring it off the property line.
How much time does she need?
I would say 30 days would be sufficient enough.
Really, to move that?
Yeah, from what her plans were. But more would be okay.
Okay. It says, welcome Mother Cluckers. Okay. What's the county's recommendation?
$50 a day.
60 days, $50 a day.
Thank you.
Next case, Craig Price, case number 2026-0328, Code Officer Julie Wilkinson, page 27 of your agenda.
This is a repeat violation and initially observed on March 5th, 2026. The address of the violation is 525 South Jackson Street in Beverly Hills, Florida. Case number is CE 2026-00328, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner is Craig Price, and he has previously been found guilty of the same violation at the same location on May 22nd, 2025. That case number is CE 2025-00340. That case was abated on July 31st, 2025 with $3,934.98 and imposed fines and administrative costs. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, findings of facts, order imposing fine, and order acknowledging compliance from previous case CE 2025-00340. Exhibit B, photos taken during an initial inspection on March 5th, 2026, and photos I took during subsequent inspections on March 9th, 11th, 18th, 25th, April 1st, 22nd, 29th, May 6th, 13th, and photos from my final inspection on May 18th, 2026. Exhibit C, a copy of the repeat notice of violation and hearing sent to Craig Price, a copy of the general pre-hearing order, a photo of the notice of violation and hearing posted at the property, and a copy of the posting affidavit.
Exhibits A, B, and C are evidence. Thank you. Okay, what's happening?
So the property is a single-family residence, 0.22 acres, and it's zoned planned residential development. He has junks, mostly it was loose trash, cardboard, and a lot of auto parts and tools. And I had spoken with him and I told him he was in violation of a repeat violation. He'd be getting daily fines. He did, he stayed in violation until March 11th, when the property came in compliance, and he remained in compliance until the inspection on May 6th. And on May 6th, he had loose trash on the ground, and that's what brought him back into violation. The property has stayed in violation to the final inspection conducted on May 18th, when there was still some loose trash, like cardboard and like an oil, I think like an oil container.
What was the violation on May 6th?
The loose trash. There, next to the trash can, there's some loose trash.
Stuff in the garbage bags?
Yes. It needs to be inside the trash container with the lid. Unless it's set out for pickup, which it was not. It was next to the house.
Okay, what's your recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative costs beginning on the date of the posting of the property, which was March 5th, 2026, and continue until March 11th, 2026, and then begin again from May 6th to May 19th. That would be 21 days at $150 a day, totaling $3,150, and a fine of $250 a day from this day forward until the violation is abated.
All right, I'll find that the property is a repeat violator, and there will be a fine of $150 a day for the days that it was in violation, leading to the $3,150 or whatever the correct amount is. What was that amount? 300.
Yeah, that would be $3,150.
50. Okay, and then $250 a day from today's date forward until brought into compliance.
Thank you.
Thanks.
Next case, Patricia and Franklin Raw, case number 2026-0275, Code Officer Julie Wilkinson, page 29 of your agenda.
Case number 2026-00275, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 9 South Melbourne Street in Beverly Hills. The property owner is Franklin and Patricia Roa. I have good service via posting the notice of hearing at the property and the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on February 25th, 2026. Photos from a corrective action inspection on on March 12th, 2026, and photos from my final inspection conducted on May 18th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Thank you. Without objection, what's been proposed as Exhibits A and B will be evidence.
This property is a single-family residence, 0.22 acres, zone medium-density residential. On my first inspection, February 25th, I observed loose trash, pile of vegetation, miscellaneous junk and debris on the property. The notice of violation was sent on February 25th, and on March 12th, the corrective action inspection was conducted. Property remained in violation, and it stayed in violation to my final inspection on May 18th, 2026.
All right, what's your recommendation?
$50 a day.
Okay. 7 days, $50 a day.
Thank you.
Thank you. Is there, well, by the way, no one from the public is here, so. And this is the last one? Almost, okay.
Next case, Kivan Vegi, case number 2026-370.
This isn't the last one? Oh, okay,
Yes.
sure.
Code Officer Alan Jonason, page 32 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer, case number 2026-00370, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 3797 East Johnson Place, Inverness, Florida. Property owner is Vahe Kavan. I hope I'm saying that correctly. This property is approximately 0.44 acres and is zoned MDR and was purchased 26 July 2024. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 18 March 2026, photos from my compliance inspection on 8 April 2026, and photos from my final inspection conducted on 18 May 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the signed certified mail receipt, and a copy of the PA.
Exhibits A and B are admitted as evidence.
On 18 March 2026, I conducted my initial inspection and observed the property to be in violation with miscellaneous junk and debris on the property. On 18 March 2026, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance mentioned earlier. On 8 April 2026, I conducted a compliance inspection and observed that the property remained in violation, and a notice of hearing was issued. I have not had contact with the property owner, and as of my final inspection on 18 May 2026, the property remains in violation.
You've not had contact with the owner, but I do see human beings in the photos.
Yeah, she just walked away.
Okay. All right.
I think it's a tenant.
I see.
I don't believe that's the property
Okay.
owner, because the property owner, I think, is somewhere else in Florida.
Got it. Well, the violation seems pretty clear from the photos, and it also doesn't look like there's been any improvement. Yeah, you're right. The mailing address is to Orlando.
Yes, sir.
Okay. What's your recommendation?
$150 per day, along with the administrative costs.
Again, I mean, it's really not that hard for them to do, so I'll say 10 days, $150 a day.
Thank you.
Yep. What case would you like to
We
recall?
would like to recall the Rivenbark case, Lee Rivenbark.
Case number is 26133, page 40 of the agenda.
Sure. Without him present?
Yes. Your Honor, the county is asking to recall this case so we can do a voluntary dismissal. Part of my confusion during the case and what I asked code about afterwards is I personally had not had familiarity with that code section. Apparently, it was struck from the code last year.
Really?
Yes, and that's why I was having such difficulty with it.
Okay.
We obviously
And
cannot
yet it's
cite...
in my folder.
Right.
It's-
I really don't know what happened. That's part of why I was like, Your Honor,
Okay.
can we go to the next case?
Okay.
But I got with code afterwards, and so we're going to do a voluntary dismissal. We'll notify him that he does not have anything, and we would like his order to reflect a or something to reflect a voluntary dismissal
That's fine.
of the action. Thank you,
Okay,
Your
well
Honor.
then let's think about this. It was cited under 4915, so my only concern, as you know, is just the due process, blah, 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 blah. But, I mean, I think you all were on the same page. And maybe we should also take a look and reprint. Every couple of years, you know, you guys make changes. I guess we should update that. By the way, it's still a big upgrade from when I started because it was like 8 years or something out of date. So you guys want to dismiss, I mean, you're just getting rid of the charges, and you want a written order to that effect.
Something so we can have it in writing, since we do have the recording, we do have it on YouTube that he had the violation. We out of an abundance of caution for due process, just something indicating it's a dismissal.
I don't mean to split hairs, but
if you want, maybe.
I wonder, I have no problem with the county doing that. You know, I think you can do it without anything from me.
Okay.
My only concern is, even if we're just dismissing it, I wonder if he should be heard. I don't think, I know it should be the greatest result, right?
Correct.
But I don't know if he would have something to say about it. So, and I don't know if he needs to, but I don't know, maybe he has some motion or some question that I haven't even heard of. I hesitate to take this up without him present, but I think you also have the authority to just dismiss it. So, I see the issue. Let me just think about it for a second. Okay, let's issue a written order that dismisses it and gives him the right to be heard on it if he elects within 20 days at the next hearing or something like that.
Yes,
Is that
sir.
okay? Something like that?
That is fine. Does Your Honor want my office to review the order, or how do you, because usually I don't look at obviously, at no ex parte, I don't look at orders before you get them, but this is something outside of Code's wheelhouse. So
I'll draft it.
Okay.
Yeah. And yeah, I'll issue it, but that's what it'll say, something like that.
Okay.
It'll give some amount of time that if he elects in writing that he wants it on the agenda, we can do that. I don't know why he would, because it's the best possible result.
It really is.
Okay.
All right. Thank you, Your Honor. We appreciate it.
Are there any other questions or concerns that we need to take up before concluding?
No, sir.
Okay, thanks everyone. The time is 11:17. This hearing is adjourned.